Welcome, and thank you so much for taking time out of your Wednesday to come attend this webinar. Jennifer and I will introduce ourselves and get started. So my name is Ashna Khanna, and I'm the Legislative Director for the ACLU of Virginia.
My name is Jennifer Safstrom. I'm the Dunn Legal Fellow at the ACLU. Really excited to talk with everyone today.
We are excited to talk about the changes in Virginia's laws that came about specifically in the criminal legal system following the 2020 session. And we've got a PowerPoint ready for folks today, which we'll be going through, and we'll be concentrating and going through the laws that did pass, what didn't pass, and taking questions. If you have any questions, feel free to put them in the chat box. We'll be sure to answer them, and we're really excited to have you on.
Sounds great. And if we can go to the next slide, just before we get started on the heart of our presentation, we did want to give a couple of COVID-19 related updates that have to do with our carceral system and detention. So we wanted to let folks know that as part of the case that the ACLU joined, that we reached a settlement agreement with the Virginia Department of Corrections that has, they have agreed to take certain steps. And so part of what we are hoping to do is share a couple of those pledges from VDOC and share information about our COVID-19 hotline, so that if people are aware of issues or potential instances of non-compliance, that way we can get that information and continue our broader advocacy efforts to make sure that those in detention are healthy and safe, including during this crisis, as well as long into the future. VDOC has agreed to prioritize their review of COVID-19 grievances, including for health issues. They are taking steps to ensure that correctional staff are properly trained on the proper use of personal protective equipment, or PPE, and other new and developing COVID-19 procedures that the department has laid out. To share additional educational information, as well as making sure that those who are confined have access to confidential legal calls at no cost so they can speak with counsel, that medical copays are being waived for sick calls, enhanced access to showers and hand washing, as well as 2 free bars of soap per week. In addition, facilities should be providing sufficient cleaning supplies for housing areas, laundering face masks daily, making sure that everyone has a clean change of clothes on a daily basis as well, and making sure that linens and other things are cleaned twice a week. In addition, ensuring safety of equipment and making sure that items like phones and doors are cleaned between uses are also, part of what we expect VDOC to be doing. And so we are hopeful that, as a result of this settlement, there will be continued protections for individuals who are currently confined, but we want to know if there are ongoing issues in facilities. So Ashna, would you share our COVID hotline information with everyone?
Yes. Sorry, I was trying to unmute myself there for a minute. So if you or your friends or loved ones or individuals who are currently incarcerated have any news around conditions of confinement and COVID-19, please email covid19@acluva.org, or feel free to call 804-803-3566. We'll be sure to put this information on the chat. And also, if you visit our website, you should see our hotline information there. Like Jennifer, basically said, is that the ACLU of Virginia is doing a lot of advocacy to ensure the safety for everyone during this unprecedented health crisis. And we know that jails and prisons are hotspots when it comes to the spread of COVID-19. And we believe that no one was sentenced to die. And so, and a lot of individuals who are currently incarcerated also have pre-existing health conditions that create even more vulnerable populations that can, when the virus spreads, it we're all concerned. We're all concerned for everyone's safety and health. And we know that families are very concerned for their loved ones. And so some of the work that the ACLU of Virginia has done is we are part of a COVID-19 Virginia Justice Coalition that has over 50 groups, including but not limited to the Legal Aid Justice Center, Richmond for All, SONG, Southerners on the New Ground, and many more groups, NACDL. And so we're really working together across the Commonwealth to bring together advocates and really ask for 3 demands. And one is that we release individuals as quickly as possible who are not a demonstrable imminent threat or bodily harm to others, that we do so as quickly, and 3, that we have oversight and transparency when it comes to testing and conditions in facilities throughout Virginia. And so we also have been calling on the governor to be using his executive power and clemency power to really start to release individuals and really speed that process up. So if you are interested in advocacy specific to COVID-19 and currently jails and prisons and releasing folks and making sure that all people are safe, please feel free to also contact the hotline and check out our website to see the action alerts and things that you can do within your community, as well as joining the coalition if you're part of an organization.
Thanks, Ashna. Now to get to the heart of what we are excited to talk to you about today, which is the work that we've done this past legislative session, and to highlight some of the changes that are coming as a result of this session, and also being forward-looking of some of the other continued advocacy opportunities and areas where Virginia could benefit from continued growth and focused targeted advocacy.
Yeah, so the 2020 session was definitely an exciting one. There were a lot of different, the ACLU works in a lot of different issue areas: gender equity, immigration, criminal justice, voting rights reform, and privacy, and so on and so forth. And so since we are a multi-issue organization, there were great strides, I'm proud to say, when it came to voting rights and some gender rights and equity, and some really exciting reforms. So if you all are interested in kind of the bulk and in a quick overview of all the different issue areas, we have our 2020 legislative report, which will kind of go through the bills that did pass, that didn't pass, and what we worked on. And so we'll share that link as well in the chat box so that folks can view that. What we're going to spend today talking about is criminal legal system, and a lot of it will be about what did pass, but also, it was one of the issues that we didn't think legislators went far enough to really make impactful change with racial justice at the center. And so we're looking forward to talking to you all about what happened, but mostly about what needs to also continue to be pushed for following sessions when we think about reforming our criminal legal system. All right. So one big thing that we worked on extensively with community partners, especially marijuana justice, was marijuana reform. And the reason that we think about marijuana reform is that because it is such a driving force when we think about racial disparities in the criminal legal system, and a driver of folks coming into contact with both police and law enforcement, but also being convicted in disparate ways. And so, with this past session, we talked a lot about what was marijuana decriminalization, legalization, and what we were hoping for and advocates were hoping for was repealing the marijuana prohibition. And so what that means is what we wanted to limit the contact between law enforcement and community members. And we didn't think that decriminalization went far enough because the police is still coming into contact with individuals, and we know that this is in racially disparate ways. And so, unfortunately, marijuana decrim did pass. We do think it's a step forward, but we don't think, it's a step forward when we think about racial equity and when we think about true reform. And so I'm going to talk through some of the bullet points, but also know that we have an entire seminar dedicated, webinar, dedicated to marijuana and what the marijuana laws mean. And so we'll be sure to share that link as well on our chat today. So just so that folks know, marijuana decriminalization did pass this past session. However, possession of marijuana in any amount continues to be illegal. This means that when folks are asked, have you been involved in any illegal activity, marijuana still counts as that. And we know that these types of questions are asked when we're thinking about access to citizenship, when we're talking about character assessments in different industries, and so on and so forth. So it's really important to know that even though it's been decriminalized, it is still an illegal substance in Virginia. Punishing possessing up to 1 ounce will be treated as a civil penalty, punishable by a $25 fine with no threat of jail time and no criminal record. However, the exception to that is intent to distribute. So that means if I have less than 1 ounce, however, police or the Commonwealth attorney believes that I am intending to distribute that marijuana, I can still be charged with a felony conviction, which is at least 2 to 5 years in jail for intent to distribute. So that's very important to know as well. And the charged individual does not have a right to counsel. So that means before, when this, I could get an attorney and I could challenge, the action of my possession of marijuana. However, now since this is a civil penalty, I will need to go out and hire a lawyer in order to fight this in court if I think that the charge is not true. And the most important thing is that racial disparities persist in every state that have rolled back on marijuana. And so we know specifically here in Virginia, if you are Black, you are 3.7 times more likely to be convicted of simple marijuana possession, even though we know usage rates are the same in both Black and white communities. And so this is just part of when we think about the history of marijuana and law enforcement of marijuana, it's one of the things that we're really cognizant of, and that advocates are ensuring that when we talk about legalization and equity, that we keep community, especially Black and brown communities who are most harmed by marijuana prohibition laws, and lower socioeconomic status communities, that we invest in those communities with any profits that do come from the industry. It's very important to note that the smell of marijuana and the stop and frisk will still be a problem, right? And so this is what we really wanted to stop, was law enforcement being able to say, okay, I smell marijuana, and therefore coming into contact with somebody. We know that it's been used, and it's going to continue to be a problem in Virginia. What also the new law makes sure is that if you are a juvenile in possession of marijuana, it will be charged as a criminal act, such as delinquency. What advocates in the ACLU really wanted was it to be a child in need of services. We did not believe that children needed to be convicted in a criminal way for something that firstly is a civil penalty for adults, but secondly, this will lead to the greater school-to-prison pipeline system when we think about our children, and we should be really thinking about rehabilitation. And basically what Rise for Youth and some of our other partners said is that this is basically ensuring that we have an entire new generation locked up due to marijuana as well. And so we're really concerned about the ways that these laws are really going to be implemented, and really concerned about the racial disparities amongst youth and amongst adult youth that will continue to persist, if not increase. And so the legislation also prohibits Virginia employers or educational institutions from requiring someone to disclose information on past marijuana-related arrests. So that's really important to note. And then the other thing to look forward to in the next session is that advocates were able to work with Senator McClellan to pass a study that would study equitable legalization and look at the racial equity portion when we think about marijuana reform. So the report, it was supposed to come out November of this year to inform legislation for the next session. However, with COVID-19, we're still waiting to hear back if JLARC can still continue to do its study in the timeline that it was initially set up for.
Thanks, Ashna. That gives us a lot to think about with marijuana and the complexities even in the messaging that required, that meant community members didn't always know what they were getting from the legislation, because decrim sounds good, it sounds safe. Unfortunately, it's still a policy that allows for those disparities to continue, as you mentioned. To move on to something else that we talked about, a consequence coming out of this legislative session is regarding the felony larceny threshold. Virginia had raised it from 500 to 1,000. So now, a theft under that amount would be petite larceny, although we'll quickly move to that in a moment. Raising the felony larceny threshold does not have an impact on overall property crime or larceny rates, as Pew has compared jurisdictions with different thresholds and their crime rates. And this is one area in which Virginia lags behind much of the rest of the country, and why advocates, including the ACLU, were hoping to get to a threshold of at least 1,500. So although this is significant in that it doubles the prior threshold, which itself was only raised a year or two ago, it's significant that we're still behind many other states. Some of the states that have the highest thresholds are Texas and Wisconsin, that have a 2,500 limit. States like South Carolina, Colorado, and Connecticut at 2,000. And many other states like Utah, Delaware, Montana, Georgia, Rhode Island, Alabama, Kansas, Maryland, and others have it set at 1,500. We're also part of a national trend to increase those thresholds, as 37 states have raised it within the last 20 years. 37 states have raised their felony larceny thresholds, and including 9, now 10 with Virginia, that have done so twice. And so that's a significant number of states that are recognizing that low felony larceny thresholds do not account properly for the cost of everyday items. How many of you have something like this in your pockets? That alone can get you, and whether or not this phone has a cover on it or not could be the difference between whether someone, has their $999 cell phone underneath that $1,000 threshold, or the $10 case that puts it over that amount. And so those, arbitrary line drawing, but in a way that doesn't fully account for the cost of everyday items and other factors, ends up disproportionately impacting women, individuals of color, particularly Black people in Virginia, and individuals with low incomes. These are, incredibly, difficult challenges for someone to experience for such a nominal offense, when a felony leads to lifetime disenfranchisement and many of the other job and other consequences that Ashna referenced that can result from interactions with the criminal legal system. Additionally, the 3 strikes provision is something we see as an opportunity moving forward, because 3 counts of petite larceny will become a felony larceny conviction. And so thus even very small, minor offenses that are far under this threshold could be accumulated together in a way that also has a disparate impact. So while that's not changing for now, we just wanted to note that that's also part of the larger felony larceny framework that has a disparate impact on folks.
Yeah, and just, Jennifer, if I'm understanding correctly, that means that if I'm, a mother and I'm trying to get food for my family, and I, steal a bag of chips 3 times in a row, that can be counted as a felony conviction. And with it, that means I lose my right to vote. That means, prison time, and that means loss of me not being there for my family. Is that correct?
Yeah, that's a great example. And that shows how it can be something that is even the 3 cumulative offenses might be far below the 1,000, even the current 1,000 felony larceny threshold, which is set to take effect on July 1, just like other legislation. So to actually clarify that point, right now, the current felony larceny threshold is still 500 until this legislation goes into effect on July 1.
Yeah, and so we know that Senator Morrissey did try to bring forth legislation that would eliminate this 3 strikes, but it did not pass.
Yes.
This is another, lost opportunity that we hope that the legislature will take on, because it's definitely a driver of incarceration and really leads to families being torn apart due to when the root problem is something else.
Yeah.
Okay, so our next thing that we kind of worked on with Lily Bridge Kennedy in her RIHD, a very great community organization that has been dedicated to Fishback. And so when we think about Fishback, this has been something that I want to say over a decade that advocates and community members have been working on. But essentially, many years ago, 367 individuals whose juries were not told about the abolishment of parole, this is who the Fishback Bill would go to, and they imposed sentences. And so with Senator McClellan, the advocates have worked to pass this legislation, so all of those individuals will now be considered for parole. And so we see this as one of those things where, the abolishment of parole in itself is something that needs to change, and we're hoping that, I know a lot of advocates are passionate about pursuing this in the next legislative session. So, but we're, it was great to see that at least in this bill that Fishback individuals would now get the opportunity for parole. And so that was something that we were glad to see. The other thing that the ACLU of Virginia has been working with the Solitary Coalition on, which is about 10 or so organizations dedicated to ending solitary confinement. We know it's inhumane, it's not effective, and no matter what you call it, being in a room, the size of a parking spot, 22 hours or more, is terrible. And we know what it does to mental health, regardless of what conditions you are when you come in. And we know, the outcomes are not great, and it's not usually used under the best circumstances. And we know, trying to relate it back to COVID-19 is that folks right now have been, if they say that they have symptoms, sometimes they get put in solitary confinement. And so we're very skeptical. A lot of states have made movement to limit and end solitary confinement and ensure that there's more better practices put in place. And so we originally, the coalition, put in a bill that would virtually end solitary confinement, especially when it came to juveniles. And that was the intent. And so, however, due to the legislative session and folks just not being ready for that yet, which was very disheartening to see. And so we're hoping to come back next year and really make individuals think critically about solitary confinement and its use in Virginia Department of Corrections and jails. It did turn into a study where now solitary confinement is going to be, the legislation will help gather data and how it's being used in Virginia local and regional jails and for what purpose. And so we're hoping by getting, gathering more data on solitary confinement, we can further put out facts in that, in public education around how it's not been useful and how it disproportionately impacts individuals with marginalized identities. We know that it causes lifelong psychological harm and trauma, and we're very, and we're currently in different lawsuits as well with the Virginia Department of Corrections, basically challenging their use of solitary confinements. And so the goal is that we'd love to see the Board of Corrections adopt accreditation standards for jails that prohibit the use of solitary, except in very unusual and very limited circumstances, and especially not within juvenile detention centers. We do not believe this practice is for anyone, especially our children. All right, so we're going to take a couple of minutes to now start to address some of the questions from some of the laws that we've already talked about and really take that into account.
Yeah, I will throw out a couple of quick points. There was a question on whether the ACLU will push the Virginia General Assembly to eliminate cash bail or amend bail laws. That's part of what we'll be talking about in this next section as an opportunity and area for kind of continued expansion. So we will be getting to that question in our next portion. And if you have any follow-ups, please go ahead and ask us at the next Q&A. There will be another opportunity. Then we also got a question, hasn't the governor not signed the decriminalization bill yet? Ashna, can you kind of clarify, you know, the legislative process and what role the governor plays in, ratifying that legislation or modifying it after it goes through the legislature?
Yeah, so the governor has signed the legislation, and so usually what happens is it goes, if it's a Senate bill or a bill by a delegate, it needs to pass one house and then it needs to pass the other house, and then it goes to the governor's desk and the governor needs to sign it, or if he has amendments, send it back to the legislature and get it voted on. So the marijuana laws will go into effect on July 1st of this year.
And then I think this might have been, thank you for sharing that, I'm sorry. The next question, I think this relates to some of what we were talking about with COVID, is do we have any information now that isn't directly from VDOC? If I'm understanding that question correctly, and that it is related to COVID, we are obtaining information through the settlement agreement, and some of that is being publicly reported to the court. And also as part of our settlement agreement, there was the agreement to disclose certain information publicly on their website, including how many petitions have been reviewed. And so some of that is coming directly from VDOC, since they are the entity that would have that information, but it is being reported publicly through these different ways. Additionally, I think there's also been a lot of wonderful reporting in Virginia and across the country that has helped shed light on issues and provide increased transparency and help surface problems and new issues. And third, part of the strategy behind our implementation of the COVID hotline was to ensure that we are trying to get that information directly from members of the community and our partners as well. And so that's part of an ongoing effort to make sure that we are information sharing. And I think through kind of a combination of those tools is how we have been able to get a lot of information thus far, and hope to continue getting more.
Mm-hmm. And something to add on to that too is the
yeah, please.
Has been sharing information, and so even through our hotline, we are critical in what we're hearing from the Virginia Department of Corrections, as we should be. And so that is why the hotline and hearing from you all is so incredibly important, so that we can really figure out what is going on in different facilities and what you all are hearing. And so we are hoping to also put our hotline information and make that public too on our website in a way that doesn't, give away the individuals who have actually reported to the hotline. So we're in the process of trying to figure that out so that we can share that information with community members at large. So really be on the lookout on our website, and then continue to be on the lookout for the Virginia Department of Corrections websites, as Jennifer has referred to, for some of those updates. I see another question from Facebook. I have contacted the coalition about 3 weeks ago via email and have not yet received a reply. How can they be reached? Well, I am, I apologize that, we don't have an official email or anything yet. What you can do is you can feel free to email me. And Fung, if you can reply with my email information on the Facebook chat. But my email is akhanna, AKHANNA @acluva.org. And so that is one way, or feel free to contact the hotline line, and it will be navigated that way as well.
Thanks, Ashna. And one more question. Can you cite the prohibition of Virginia employers requiring disclosure? Is this grandfathered? I think this question relates back to what we were discussing about having to disclose offenses, sometimes even civil offenses for different situations. I think what Ashna was saying is that not all employers may require this. It's not, it is not required for every employer to ask, but for all employers who do ask, and many do, this can create a burden and present a hurdle for those individuals. And to connect it to kind of the state component, there are many official licenses and other types of opportunities that require that disclosure to the state for other purposes. So for instance, to become an attorney in Virginia, I had to report extensively, not just on any criminal violations, but also on any civil infractions. So if I did not disclose even, a speeding or parking ticket as a civil infraction, I could still be penalized for not being honest on my application, and could face serious consequences for not disclosing that. And so I think it could come up in different ways, and we were trying to give the example of both employers as well as licensing, and there may be some crossover in state employers, but it could be for it both in the private context as well, even if it's not every single employer. I hope that kind of answers that. And Ashna, and anything else you wanted to clarify about kind of that prior discussion?
No, I think that like we're all in this really weird boat where this legislation has passed, right? And so we're all waiting to see the different ways that it gets implemented. And that's why, again, please see our marijuana webinar. We go into detail with that, but we're also hoping to have follow-up post July 1st to hear from community members about how these different laws are being implemented and the holes that, will probably exist then. This was a very debated law, and I'm proud to say that part of the original bill actually added new criminal crimes, right, like smoking while driving, and advocates were able to get some of those additional for decrim get some of those additional laws off the books. But we're very skeptical on how it's going to play out, and like Jennifer said, there's a lot of different forms, and so we're hoping to continue to follow up. But if you all also hear of ways that this has impacted you, I know some local jurisdictions are making it so that testing is not, there for certain job, city and local jobs. So we're interested in hearing from you what different things that, Virginia officials and local officials in your district, and what are the experiences that you all are having as well. All right, so I think we're going to go to our next part, which is going to be talking about eliminating racial disparities in the criminal legal system and kind of future changes and reform. Well, we'll touch on things that actually didn't happen. Either, the bill was proposed, it died, it didn't get a vote on, or things that just didn't go far enough. And so, like I said, a lot of different advocates really felt strongly that when, even though there were some great laws that were passed by the legislature this past session, criminal legal reform, especially when it came to racial disparities, was something that was left behind, that we didn't pass progressive, impactful legislation that would really help reform our system, and that we know is broken, or, as I like to say, is working exactly as folks had intended it to work. And there were not enough laws that in our belief that passed to make real progress and change on this front.
Yeah. So we're going to start by talking a few of these issues. And so we'll go back and forth and kind of give a short description, and Ashna can give a short kind of legislative update about each of these pieces. So the first is, lots of aspects of our pretrial detention system, but chiefly among them, the right to counsel on first appearance. Having an attorney the first time you appear in court is incredibly important and has a huge impact on the outcomes that result from those proceedings. The criminal legal system is incredibly complicated and nuanced. Having an attorney, especially early involvement of counsel, can help identify defects in a case, improper charges, or other types of procedural and substantive errors that can help safeguard an individual's rights before that process extends. We know that individuals, especially those who have extensive pretrial requirements imposed upon them, can suffer in a number of ways, including because of lack of repayment of fines and fees, of challenges, later on in getting a reduction of bail, and other types of, significant aspects. One study cited that defendants who had representation were 5 times as likely as those without representation to receive a reduction in bail amount. And so being able to even experience your pre-trial, to eliminate that pretrial detention because of more accessible bail, links closely to this concept, and one of the reasons that counsel is so important. Ashna, do you want to share a little bit about some legislation on this area? And then we can talk about bail.
Yeah, no. So essentially, so we have a pretrial justice coalition, and that has many groups, the Legal Aid Justice Center, the ACLU, and so on and so forth. And so a lot of community advocates thought it was long past time that Virginia needed to reform its pretrial system. Not to mention, I think that statistic right there, that 46% of individuals who are in jails have not yet been convicted of a crime. That is almost half of our jails. And so to me, we know that it only takes 3 days to lose, custody of your children, lose job, get behind on payments, lose, all of these unintended consequences, lifelong altering consequences that occur just behind even, not being convicted of a crime yet under pretrial. And we'll get to, the bail and issues like that. But, kind of the first thing that we called on was the pretrial transparency bill, is what advocates originally worked on, that unfortunately for now, it's been 2 years, that still did not pass. And then also advocates worked on getting legal counsel at first appearance, eliminating presumptions, and both of those bills did not pass as well. And so it really or got altered, where it really isn't going to make a huge impact. And so we're really disappointed in the way that the legislators have really thought about reforming the pretrial system in ways that are, other states have been making other great strides on.
Yeah, and to clarify a little bit more on the presumptions against bail, part of why this early appearance is so important is because bail determinations are a key point in proceedings for all of the reasons that Ashna just mentioned. But an additional complicating factor is that for certain offenses, there is a presumption against bail. And so essentially, unless the judge or magistrate thinks the person will, most of the time I should say, a judge will only order bail if they believe that the person will not come back to court or presents an unreasonable danger to themselves or the public. These presumptions against bail for certain offenses means that the judge, it takes away judicial discretion to make that determination for each person based on all of the facts and circumstances that that individual might be experiencing. And because of the nature of the offense for which they're charged, it's much more difficult for them to become entitled to bail because of this presumption against them that creates a much higher hurdle for them to have to get over before they can be considered in that way. And so, it is one of the many challenges that is part of the larger, challenges that people experience as part of paying fines and fees and being able to access representation that has a kind of day-to-day consequence for individuals who may be detained as a result.
Yeah, and kind of to go, off of that, no one should be, again, incarcerated because they can't be due to their socioeconomic status. It should be, am I a flight risk? Am I a risk to the community? And am I a risk to not coming back? And we know that a lot of times, where the way other states have made reforms is that folks are going to come back. It's simple things like text message reminders and different other advocacy that other folks have, other states have really gone about that we know folks are going to come back and that people are being held just because of their inability to pay bail. I do want to say, however, in the question that it was phrased, would we support eliminating cash bail? The answer to that would be no. So we don't think that, the reason we don't think it's just an end cash bail campaign is because other states that have ended cash bail, and like we've seen in New Jersey in the way that they went about transforming their pretrial laws, is that sometimes it leads to higher incarceration rates, because then the judge has two, options. One, I can't use cash bail, so do I leave someone in or do I not? And we all know that different people have different assessments on what does it mean to be a threat. And we know that the pretrial risk assessment tools are, indeterminately, like the institution of pretrial risk assessments does not have equity at the center of it, right? Because there's usually data points that are going into it, such as race, your job, that doesn't account for the institutions and the actual lives that people have at play. And so we're really struggling on that front as well. So there's no perfect answer, but however, we do want to, we don't think ending cash bail is the answer, or, eliminating risk assessments, but we believe making, risk assessments more equitable, more accountable, and then being used as one factor of the judge considering to someone's opinion versus the only tool for someone's opinion is much better, and looking at cases on an individual basis. And so those are two things that we really hope for. We're still, again, pretrial transparency did not pass. There was not money in the budget to even start in what advocates had started with saying, why don't, we have a Commonwealth attorney, judge, and sheriff willing to work together to try it out in one jurisdiction. And even that as a mini project was not able to pass. And so we're seeing that at every instance, when we know these are smart reforms that would save, millions, not to mention people's lives in their futures, that this is just being, is a system that is incredibly broken, and there has not been progress when we think about pretrial reform in Virginia.
And that data is important not only in identifying the problem, but finding the most effective solutions. So if we want to go to the next slide, we'll quickly talk about a couple of last key areas and then hopefully take a couple more questions at the end.
All right, so expanding expungement. Expungement was one thing that advocates were very passionate about this session, but unfortunately did not pass. Record expungement is an important factor when we're thinking about reentry, right? And so if we're thinking about the concept, I had so many community members come to me and say, Ashna, I still can't get access to housing, jobs, and so many different opportunities because the mistake I made 30 years ago is still following me today. And we know that Virginia doesn't have automatic expungement. It doesn't have any of these systems that allow for really reentry. And when we think about rehabilitation and reentering society and being a productive member and having opportunities to be able to do so. And so when charges are dismissed in Virginia currently, it's because there's not enough evidence to prosecute or a person is found not guilty. And so right now in Virginia, it's even a very tedious process if I were to be found, actually, guilty, and then, wrongfully convicted of a crime. It is a very, long process to even get that overturned. And so we're finding that expungement is still a huge area of opportunity that advocates and, the ACLU hope to continue to push for in the following sessions and keep legislators accountable for. It was something that was left off of the marijuana decrim bill. It was something that we had proposed that we said, if we just expunged records, we wouldn't have to think through the money and all of that. If we just said any future convictions will be, expunged. And so it's something that we're still trying to push for, but it's something that's still an issue.
And that's just kind of one example of how people may face reentry barriers. We've already talked, and provided some examples of how it can impact jobs and kind of professional credentialing opportunities, but also can impact things like safe housing and education. So, disclosure for student loans or other types of federal eligibility for certain programs excludes those with convictions, and there are a number of housing providers that also restrict sometimes inappropriately based on those aspects of someone's background. And this is something that, we as the ACLU of Virginia have tackled on the litigation front in a case last year that was settled, that was brought on behalf of Housing Opportunities Made Equal of Virginia. We sued an apartment complex in Chesterfield, Virginia, that had an incredibly restrictive policy, relying both on federal and state law, but increasing those protections so that, there is, additional protections for individuals is important in safeguarding their rights and making sure that it is protective of individuals to be able to access, essential services. And this is also something that has, impacts on families and their day-to-day experiences. If someone receives a felony conviction, and lives with a family member, in a particular unit, that they also could be disqualified, even if they're not the primary resident or applicant. And so it's something that has a significant impact on families holistically, and not just an impact on the individual with a conviction. So making sure that policies are reasonably related to community safety, making sure that there is an individualized consideration of every applicant that accounts for all of the individual's facts and circumstances, the timeline since of their conviction, other types of reparative and restorative acts that show that they are essential members of our community, is significant in making sure that full reentry and full reintegration in society is something that happens for everyone who is returning to our communities. And then to talk quickly about the school to prison pipeline, which refers generally to push out from the school system, increased interaction with law enforcement, which is, promulgated by a number of different policies ranging from zero tolerance efforts to, disproportionate impact for particular communities, including students with disabilities who, are disproportionately represented in school discipline issues. And so, Ashna is going to share a little bit about, some Virginia legislation and statistics, but on the whole, the NAACP's research shows that Black students are disproportionately disciplined for more subjective offenses, including things like disrespecting a teacher or being perceived as a threat, than did their white counterparts on a national level, even when the behaviors were relatively the same or identical. And so, this is just kind of one data example to show how this is being applied and also has significant consequences in pushing individuals into the criminal legal system, especially at a young age, when many of these consequences already have such serious lifelong effects.
Mm-hmm. Yeah, and so I would like, genuinely, because, we got 7 minutes left and I want to hear from you all and be able to answer questions. The Legal Aid Justice Center has been a really huge, and Rise for Youth have been two organizations at the forefront. And so if you're more interested in finding out about what about school resource officers and the specific legislation that has passed this past session, because we did make some strides when it came to the school to prison pipeline, I would please, defer folks to those two websites and really follow their work and support Rise for Youth and the Legal Aid Justice Center. But as you can see on the slide and what the statistics show and what Jennifer had basically said was that it's discriminatory, right? And so that's our entire, that's really what our entire presentation has been about, is how all these systems and institutions are not set up for folks to be treated equal. And what is the outcome of that is all these racial disparities that continue to exist from childhood all the way to reentry. And so, how individuals enter the system and the conditions within the system that don't allow, and then reentry. And so what we're seeing is that we need to continue to push, because it's such a complicated system in a way, we need to continue to push at all forefronts to ensure that We're passing and we're addressing racial disparities in school to prison pipeline, in conditions, in pretrial confinement, in Commonwealth attorneys, in the conditions like solitary confinement, and then when we think about reentry, such as expungement and more. On the next slide, two things quickly is like part of that is sentencing, right? And so part of what we want to do is ending mandatory minimums, abolishing the death penalty, increasing alternatives to incarceration, especially when we've seen legislation. If you're the primary caretaker of the household, a lot of times it's not productive for you to not be in that household anymore and taken away from your family. And so that is one huge area that we're hoping to make strides in. And then the other is eliminate racial bias in policing. I mean, that's one of the reasons we've been working so aggressively for marijuana reform, especially when it comes to racial equity and making sure that there's an equitable lens on laws and enforcement going forward. But we're even seeing that getting data is so hard. There was another bill that came forward this session that had to do with use of force, right? We're seeing, unfortunately, we're continuing to see that police officers are not being held accountable and that we're losing community members to such violence. And so we're really hoping that we can get data on that and abuse of force to hold police accountable. And even that was not being able, had not passed. It was Delegate Guzman who had introduced the legislation. And so what we're seeing on all fronts is that even when we're just asking for data to enact more progressive change, that there's still struggles in getting that, even though we had legislators that are really passionate about the criminal legal system. So there's definitely need to be more accountability on that end.
In terms of what's next, generally the ACLU looks forward to continuing to work on these issues. These are some of, we think some of the most important pressure points moving forward and some of the areas where there's the ability to gain the most traction and make the biggest impact in Virginia. So we are looking forward to continuing to collaborate closely with all of our partners to make sure that we are thinking strategically about how to tackle these issues, especially through the legislature, but also through our litigation and community advocacy work.
Mm-hmm. And we're doing these webinars now, but as it gets close to the legislative session and as we figure out how that looks, in the COVID-19, we encourage individuals to stay tuned in about action alerts in our legislative program and continue to be advocates as constituents to your own legislators to hold them accountable.
So now we look forward to taking some more questions with the few minutes that we have left. I see one on what is being done for inmates being held in jail because they can't go into a CCAP program because of COVID-19, and the that acronym standing for Community Corrections Alternative Program. So this is something that we are working to obtain more information on, and that we, encourage specific reports or questions or issues on through our hotline. We, are seeking to get more information on this exact issue. We believe individuals while detained should, be protected, in compliance with CDC guidelines and recommendations for how individuals, should maintain that, including their subset of health recommendations for prisons and jails, and their targeted advice for those populations. And we are looking more into what has been happening as part of our settlement agreement. There's been work to expand the timeline for which home plans are in development. So for those who are transitioning out, we are trying to reduce those barriers to make sure that that transition for those who are being released is as quick and effective as possible. But for those in specific initiatives, we're still in the process of getting additional information, and are looking to continue supporting all of those in need. So I hope that answers some of your question and also leaves it open for us to continue that conversation.
Yeah. I'm seeing another one. So what's the best method to close the school to prison pipeline? What proposals have the ACLU discussed to lawmakers to close the gap? So there's a lot of different methods, right? And so two things that I know that here at the ACLU that we've been very passionate and really have been trying to push for is we don't believe, incarceration is the answer. We know that a lot of times many of these children have learning disabilities or histories of poverty, abuse, or neglect. And so that we truly believe that it needs to, that schools would benefit from additional educational and counseling services instead of being isolated, punished, and pushed out. Zero tolerance policies are usually ones that criminalize minor infractions and mostly children who have marginalized identities. And so, we're not really, we do not like zero tolerance policies, as well as school resource officers. We want to make school a place where it does not, we're not thinking about the police needing to come in, and that we're thinking about all the different stages before that. And usually school resource officers are another way or system that, instead of protecting our youth a lot of the time, doesn't protect everyone. And it results in outcomes of, again, racial disparities and situations leading to increased school to prison pipeline.
And some of our,
I would really encourage folks to tune in to Rise for Youth and the Legal Aid Justice Center, who have been great advocates on this work.
Yeah, and I was going to say our education advocacy isn't just limited to the criminal context. We have ongoing litigation on behalf of a former high school student who was not able to use restrooms that accorded with his gender identity in violation of federal law, and again have done other work outside of the legislative sphere and even outside of the criminal sphere related to education, but appreciate how Ashna acknowledged the intersection of all of these issues and the importance of a school being a safe place where students can learn and not be impacted by these factors in a disparate way often.
I don't see.
Yeah, I'm not seeing any other questions, and given that we are now just over time, I think that we should end it here. But I will say on behalf of myself how much I appreciated getting to speak with you today about all of our work, and how much I applaud all of Ashna's efforts as our legislative director throughout this session, and how excited I am for the work we've done and the work that we'll continue to do on behalf of our communities.
Agreed. Thank you so much, everyone, for really taking the time out to come. Again, please, I encourage you to stay in tune. We really, as you've seen in this presentation, need to continue to pass major reforms when it comes to the criminal legal system. And so the work is nowhere near done. Please stay tuned to hear about more webinars and more ways and opportunities to hold your lawmakers accountable.
Thank you.